The committee will come to order. When we, Senator Graham, so the next is Senator Durbin. Senator Durbin, I yield to you.
Thank you, Mr. Chairman. Mr. Attorney General, thank you for your appearance. I'd like to call your attention to a matter which has been discussed here, a matter of discretion by the Attorney General of trying an accused terrorist before the tribunals of our land that are available. In fact, the terrorist who was being tried was accused of being the 20th hijacker on 9/11, and the decision was made by the previous administration to try that terrorist in an Article III court in the Eastern District of Virginia, literally 15 minutes away by car from the Pentagon, where on 9/11 innocent lives were lost and families still grieve to this day, and we joined them in that grief. That decision was made in 2006 to try Zacarias Moussaoui in the Eastern District of Virginia. I do not recall any complaints from either the Republican side of the aisle of their president, President Bush's decision through his Department of Justice to try that case in an Article III court, or on our side of the aisle either. And I ask you, as you reflect on the parallels between Khalid Sheikh Mohammed's prosecution in New York and this prosecution in Eastern Virginia, can you tell me what the distinction might be? Why Khalid Sheikh Mohammed should be tried in a military commission?
Well, again, we've learned, I think, a great deal from the Moussaoui trial, which I think will assist us in the conduct of the Khalid Sheikh Mohammed trial and the other four. Again, I think determinations are made as to what's the best forum for a particular case. What I have tried to do is make individualized determinations looking at each of these matters and trying to decide what's in the best interest of the American people in terms of safety, what is consistent with our values, and have made determinations that some should go to our Article III courts and some should go to the reformed military commissions.
I'd like to quote former Mayor Giuliani, who has been outspoken about the trial of Khalid Sheikh Mohammed and what he said about the Moussaoui trial, tried in an Article III court. He said, at the same time, I was in awe of our system. It does demonstrate that we can give people a fair trial, that we are exactly what we say we are. We are a nation of law. I think it's going to be a symbol of American justice. That was the trial of an accused terrorist, 20th hijacker, 9/11, in an Article III court within a minute's drive away from the scene of that horrific loss of life at the Pentagon. And I struggle to find the difference. But I want to draw one point, too. You refer, accurately so, to the reform military tribunals, reform military commissions. And it reflects the fact that because of Supreme Court decisions in Hamdan and actions by Congress, at the time controlled by the Republicans, that we have changed the laws when it relates to military tribunals to try to come in conformance with Supreme Court requirements. You've noted that since 9/11, only 3 have been successfully tried before military tribunals accused of terrorism. And I want to ask you this question. As you referred the 5 to military tribunals under the reform, are you not also aware of the possibility that some will challenge this new procedure as to whether or not it conforms with earlier Supreme Court decisions, which may lead to procedural delays and some delay in the final outcome of those tribunals?
No, that is a distinct possibility, and something that we will have to try to deal with, or the prosecutors in that case will have to deal with, and that is something we will certainly not have to deal with in bringing Khalid Sheikh Mohammed and his cohorts in the Article III court in Manhattan. We have a 200-year history of trying cases, these kinds of cases, and so the question of legitimacy is not an issue that we'll have to deal with at all.
So we have a very close parallel where the Bush administration decided on the 20th hijacker for 9/11 to prosecute him in the Article III court in a venue very close to the scene of the horrific tragedy. We have a situation now where some are calling for any future trials to be in military tribunals or commissions, which have procedures still not ruled upon by the Supreme Court, which could lead to some ultimate delay in the outcome of those proceedings. I think those are things which should be made part of this record in our hearing today. I'd like to move, if I can, to the issue of the future of Guantanamo. I support the administration's decision in closing Guantanamo. It is consistent with positions taken by General Colin Powell, who said if I had my way, I wouldn't close Guantanamo tomorrow, I'd close it this afternoon. Secretary of Defense Robert Gates, under both President Bush and President Obama, has called for the closure of Guantanamo because of the danger that it presents to our troops in the field. President Bush, on 8 separate occasions, called for the closure of Guantanamo. Admiral Mullen, chairman of the Joint Chiefs of Staff, called for the closure of Guantanamo. General David Petraeus called for the closure, all believing that the existence of Guantanamo was, in fact, an incitement for those who would do harm to our soldiers and to the American people. And so now there is a possibility that we will find another venue. And one of the opportunities or possibilities is in my home state of Illinois, in a small town of Thompson, fewer than 1,000 people, on the northwestern part of our state, a rural area. And the Bureau of Prisons and Department of Defense have been out to look at this site. It is my understanding that they are considering the configuration of this facility if it is chosen. And one of the things they're proposing is to put a new perimeter fence beyond what currently exists at this maximum security prison, built 8 years ago and never fully occupied. And it's my understanding that if this new perimeter fence is installed, this would indeed be the most secure, the safest maximum security prison in America. Is that correct?
That is correct.
And to date, we have never had an escape from a supermax facility in the United States.
That is also correct.
You mentioned some 300-plus convicted terrorists, domestic and international, being held. In our state, some 35. And incidentally, one of those happens to be a man accused of being in a sleeper cell for al-Qaeda, al-Bari, who is serving in the Marion Federal Penitentiary without any danger to the surrounding community. I might also ask, one of the congressional critics in my state has said that there would be a requirement if we brought the Guantanamo detainees to Thompson, Illinois, that they would be allowed up to 10 visitors, which means if there were 100 transferred, we would, in his words, have 1,000 jihadist followers going through O'Hare, trekking across Illinois to visit, as he said they were legally entitled to do. My understanding is that those held in military facilities, and this would be a military facility for Guantanamo detainees, are denied access to any visitors, family or friends, and the only visitation is from legal counsel. Is that your understanding as well?
That's my understanding.
So the statement that's been made about 1,000 jihadist followers streaming across the highways of Illinois is inconsistent with the law.
That's not consistent with my understanding of how people are held in military detention.
Thank you, Mr. Holder. Appreciate your testimony.
Thank you very much, Senator Durbin.